Hello, what's going on in here? Bernard the Barrister Bear. Hello. And this video is called Where Have All the Law Codes Gone? Well, that's a strange topic, isn't it? Where did they go? Well, Bernard is correctly asking, where did they go? Well, in fact, they went many years ago in England. There were law codes, yes, in Anglo-Saxon times. And more recently again, there's been pressure to codify the law. What does that mean exactly? Codify means to bring the law together based on principles and all under one cover. Either a single code for the whole law, or, that may be a bit too ambitious, or a code of laws for one area of the law and another code for another area. In fact, there are codes like that, particularly in the Roman tradition, the civil law tradition as it's called. Civil here not being civil as distinct from criminal, but civil in the Latin sense of the civil code of Justinian, which is simply a compendium of all laws. So you could have a code of criminal law, you could have a code of civil law, you could have a code of civil procedure separately, you could have several separate codes. And that is usually the case now in Europe. Most European countries have codified law. France, Germany, Italy, Spain. Most countries in Europe and beyond. Japan. They've copied the European model. Britain hasn't. Interestingly, America has, although American law is common law based on English law, and yet it is largely codified. And it is codified on a state-by-state basis, because America, United States, is a federal state. And there are 50 states. So each state has its own codified law to greater or lesser extent. Even a tiny state like Wyoming, tiny in terms of population, about the size of Birmingham, I think, has got its own codified law. Most of the codes are very similar. Some are not as completely codified as others, but they all have some degree of codification. A code enables the courts to find very quickly the applicable principle of law. English law is not a question of finding the principle. Very often there is no principle. And the idea that the court can make up a principle is completely wrong, because that's making law, which is legislation. That's not something that judges should be doing. Judges should be interpreting law and applying the law, but not making law. Chief Justice John Roberts in America made this point in a well-known remark during his confirmation hearings, where he said that as a judge, you are essentially acting as an umpire in a football game. You're not a player. You don't make the rules either, but you decide who is right and who is wrong in terms of the actions of the players. You work according to the rules. You don't make the rules. There are those who say that John Roberts was not being entirely frank and that he has actually overstepped the mark himself on occasion. Well, maybe. But the point is that that is the correct concept. That is the correct concept. Because, again, it's to do with democracy. The body that is empowered to make law is the legislature, which in Britain is Parliament, and in America is Congress for federal law, and in each state, the state legislature. Every state, every one of those 50 states, has its own legislature. Now, back in 1965, in this country, in England, a law was passed called the Law Commission Act 1965, which introduced a body called the Law Commission, and one of the functions of the Law Commission was said to be codifying the law. And the Law Commission produced their first report in 1967, in which they said that they were hell-bent on, I didn't quite use that terminology, on codifying the law. They mentioned particularly codifying contract law. Well, that's a pretty tall order. What has been done about it? Nothing. Nothing at all. 1967. Nothing. They also said that even that was not all they would be doing. That code of contract law would form part of a bigger code called a commercial code, which in turn would form part of a yet bigger code called a code of obligations. Oh, that would be wonderful. Obligations. Because, of course, they're quite right. Contractual obligations are only one type of obligation that the law imposes on people. The other main type is imposed by the law of tort. Tort. What's called in Scotland delict. The most important part of that being negligence. But there are many other aspects as well. Golly, if one had a code of obligations, how far have they got towards that goal? Nowhere. Nowhere at all. Why? I don't know. there has been a resistance to it. Another one they mention is the possibility of producing a code of family law. Well, wouldn't that be wonderful? Again, no progress there either. Criminal law they don't mention, but actually criminal law is largely statutory now, so actually not in such a bad state compared to the others. Unfortunately, there is a residual feeling amongst a lot of lawyers and some judges that the law is best left as it is, because that gives the courts, i.e. the judges, greater powers to interpret and to make law. But that's completely wrong. Judges should not be making law. I don't blame the judges, though. I blame Parliament, because Parliament is the legislature. And according to the British Constitution, the supremacy of Parliament is the very, very centre of the Constitution, the very basis of the Constitution. The supremacy of Parliament. What does that mean? Well, it really means legislative supremacy. The term used actually is sovereignty of Parliament. It is even more extreme, the sovereignty of Parliament. How can Parliament be sovereign? All it does is pass laws. Fine. That's how it can assert its power, by passing laws. Legislative supremacy. But actually, of course, in political terms, Parliament is controlled by the government, by the executive. So that's really where the fault lies. The fault lies in the government, the executive, not stepping up to the plate and passing legislation, even without codifying the law. Consolidating would be something. There are certain areas where the law has been consolidated. In other words, where one area of the law has been made, has been united, has been consolidated, has been made one. Like, for example, company law or insolvency law. These are fairly small areas, though. We do not even have consolidation of defamation law. Instead of that, there are about 6 different statutes piled on top of one another and on top of the common law, all of which are still valid. The situation cries out for change. More next time. Bye-bye.